Life. We'll start.
Good morning, everyone, and warm welcome to the second lecture of the SCAORA lecture series. I am Aditya Giri, member executive of the Supreme Court Advocates on Record Association, and it is my privilege to moderate today's session. Today, we gather to explore a crucial aspect of our legal system, public interest litigation. This topic is not only relevant, but also critical in ensuring that our courts remain accessible to all, and that justice is served in the best interest of the public. As we delve into the important subject, we are fortunate to have a distinguished speaker who needs no introduction. But before I invite our speaker, I would like to welcome Amit Sharma, Vice President of SCAORA, to introduce our esteemed guest, Dr. S. Muralidhar, Senior Advocate and former Chief Justice of Odisha High Court, who has graciously accepted our invitation to share his vast knowledge and experience on today's topic. Sir.
Good morning, everyone. Welcome to the second SCAORA lecture series to be delivered by Dr. S. Muralidhar. Mr. S. Muralidhar will be delivering lecture on public interest litigation. I would want to introduce him a little bit, though he doesn't need any introduction for that matter. Dr. Muralidhar has been an inspiring human being for all of us in many ways, be it in academician, profession, sports, writing, simplicity, selflessness. The areas are endless. I feel privileged to have been learning from him in every sphere of life. Besides being a topper in the Advocate on Record examination, he also became the youngest part-time member of the Law Commission of India, appointed in the year 2002. He is known for his pro bono work. The list is very long, but some of his important pro bono work I must mention. Those are cases related to Bhopal gas victims, cases related to rehabilitation of people by Narmada dams, cases of rights of manual scavengers. Dr. Muralidhar has provided much valuable legal acumen to the Election Commission of India, National Human Rights Commission, by representing them before the Honorable Supreme Court of India. He has written many articles, essays on various socio-legal issues. He has also authored a book named Law, Poverty, and Legal Aid, Access to Criminal Justice in the year 2004. Dr. Muralidhar has a rich experience of being on the other side of the bench for more than 17 years. He came to be elevated as a judge of the Honorable Delhi High Court at a very early age of 45 years in the year 2006. It was his cause list which mentioned for the first time in the history of Indian judiciary that tried to avoid addressing the judges as my lords or your lordships. He went on to become the 32nd Chief Justice of the Honorable High Court of Orissa Orissa on 4th of January 2021, where he transformed the working of Orissa judiciary. He holds a record of setting up of highest number of paperless courts in the state of Orissa, which became the first state in our country to have so many paperless courts in a span of just 2 years. He has delivered many landmark judgments during his tenure as an honorable judge. Some of them are on gender discrimination, housing rights, criminal law, constitutional law, arbitration laws, administrative law, intellectual property laws, service laws, labor laws, taxation. You name a subject and we have a landmark judgment authored by Dr. S. Muralidhar. He's now back on our side of the bench and continues with his journey to fight for the poor and the needy as always. One thing I am definite is that we are going to understand the concept of public interest litigation in its true sense in the lecture to be delivered by Dr. S. Muralidhar today. And I must remind all the listeners that this is being live casted in YouTube, so you can leave your questions in the chat box, which would be answered by Dr. S. Muralidhar at the end of his lecture. So I warmly welcome, sir, on behalf of SCAORA and all the listeners.
Thank you, Amit. I'm really honored and very delighted to be addressing lawyers, not just of the Supreme Court Advocates and Record Association, but others who've joined in, including some of law students, some of whom are interning with me here and who've helped me for preparing this lecture. This is a topic, of course, with which all of us are familiar, dealing with it on a daily basis. This is also a topic that keeps the press on its feet, and the coverage of courts these days is far more extensive than what it was a couple of decades ago. The origins of public interest litigation has always fascinated me, and much has been written about PIL, but everybody wants to know, how did it begin and why did it begin? So you have speculations on what could have triggered this innovation by the judiciary. One we must understand is this innovation, where the court reaches out to the masses, is an innovation that came from the end of the judiciary. It was not lawyers who suggested to the court, let's have public interest litigation. And to understand this, we need to go a bit back in time. I've dealt with some of this in my book on legal aid, which Amit was referring to. And that exercise is what triggered my curiosity. Because I have myself been a PIL lawyer, filing PILs, watching PILs in court, reading judgments in PIL cases. But it has always been a question as to where it all began. We normally understand that the Husainara Khatun case, which began in January 1979, was the first major PIL case that was decided by the Supreme Court of India, which dealt with under trials in jails. And that orders, those series of Husainara orders that you find reported in 1980, Volume 1 SEC, page 81, you will find Husainara 1, 2, and going on to 8. The earliest of those orders, although the reported order is 12th February 1979, the first order apparently was passed on 5th February 1979. And it was based on two newspaper articles that appeared in the Indian Express, authored by K.F. Rustamji. And those two articles were January 1979. So for a long time, I used to think that the origin of PIL was these two Indian Express articles that led Justice Bhagwati's bench to take it up and treat it as a writ petition. Ms. Kapila Hingurani, the late Ms. Kapila Hingurani, being the advocate for the petitioners in that case. But when we did more research, we found that the origin lie elsewhere. It takes us back to 1957, the Kerala Legal Aid for the Poor groups. Justice Krishna Iyer at that time was in a different avatar. He was the labor minister in the Namboodiripad government in Kerala. And it on his insistence that these rules, Legal Aid for the Poor rules, were formulated. And this is acknowledged in an article in 1981. What is unique about these Kerala Legal Aid to the Poor rules is that it recognizes class action litigation. It recognizes that there are groups of people, and whom they had in mind were scheduled castes and scheduled tribes, who could not bring cases because of poverty, disadvantage, before the courts, and they needed assistance to bring cases to the court. So although it was a legal aid for the poor rules and had many of the facets of the legal services delivery that we have today, it had an important component of class action litigation, representative action. So the earliest recognition that there may be groups of people, large sections of people in the Indian population who cannot afford to go to the courts to assert their rights, the earliest recognition was in these rules. The next formal recognition that we get is in a report of the Gujarat Committee on Legal Aid, which was set up in 1970. And this was set up in the Gujarat government. It was a committee chaired by none other than Justice P.N. Bhagwati, who was then a judge of the Gujarat High Court. And Justice Bhagwati happened to visit not only the US, but also Europe as part of that committee. And by this time, some of you would be aware that public interest law was already a part of the US jurisprudence. In the United States, in 1963, was delivered the judgment which goes under the title of Gideon versus Wainwright. Now, I don't know, many of you have heard of Gideon. There's an excellent film made on this entire Gideon case, which goes by the name of Gideon's Trumpet. I think it's also available on YouTube. It's a movie in which Henry Fonda acts. Basically, a prisoner, a convict facing a felony conviction, wanted to appeal to the Supreme Court and ended up writing a postcard to the United States Supreme Court. And that was treated as a petition. So this whole branch of public interest law had already started developing in the US. In fact, there is a quotation from a Ford Foundation report on public interest law in the US, which was brought out in 1976, which says public interest law is the name that has recently been given to efforts providing legal representation to previously unrepresented groups and interests. Such efforts have been undertaken in the recognition that ordinary marketplace for legal services fails to provide such services to significant segments of the population and to significant interests. Now, this is a 1976 report, but Justice Bhagwati mentions, as a result of his visits to the US and Europe, that this public interest law concept should also be brought to India. So that report is a very, very progressive report that he authored when he was in Gujarat as a judge. So from two different ends, one from the south and one from the west, you have two judges. Justice Krishna Iyer, you should all recall, was still very much in politics. He went on to become a power minister. For some reason, he was never a law minister. So he was a labor minister, and then he was a power minister. And then he came back to practice and was elevated as a judge of the Kerala High Court in 1969. And very soon came to the Law Commission. And we are now in 1973. So there's a committee for examining the whole aspect of legal aid. And he's made chair of that committee. So you have a 1973 report of this committee on legal aid, chaired by Justice Krishna Iyer, which gives out a full report. And part of that report is devoted to class action litigation and mentioning in particular public interest litigation. So we are in 1973 now. This is even previous to the emergency. And so you have the 1957 Kerala rules, you have the 1971 Gujarat report, you have the 1973 report. Very significant things happened. On the same day in July 1973, two judges got sworn in the Supreme Court of India. One was Justice Krishna Iyer, the other was Justice Bhagwati. And their presence in the Supreme Court started then in 1973. But it was not till 1978 we start having actual judgments on the aspect of public interest litigation. Now, I think Justice Krishna Iyer took an early lead with the Dabholkar case. Many of you are probably aware of this. The judgment goes by the name of Bar Council of Maharashtra versus M.V. Dabholkar. And it is a judgment dated 13th August 1975. So just to give you the sequence, we had the 1957 Kerala rules, the 1973 Gujarat report, the 1973 Krishna Iyer report. And now Krishna Iyer is sitting on a bench in the Supreme Court. It's a 7-judge bench, and it's delivering the judgment in Bar Council of Maharashtra versus Dabholkar. And in that judgment, you will have a whole passage devoted to public interest law and the expanded notion of standing. And this, I think, is an early recognition of the new role that lawyers are required to play, where the traditional rules of litigation, which is adversarial, where people have to have an interest in the cause, that was expanded. So the first attempts at introducing the newer concepts was made in the Dabholkar case, which dealt with the disciplinary powers under the Advocates Act. And the short question there was, can a Bar Council of Maharashtra be aggrieved by a decision of the Bar Council of India? And can it itself espouse a cause? And there, of course, they recognized that Bar Council of Maharashtra, which is a state bar council, had the locus to espouse a cause aggrieved by the decision of the Bar Council of India in disciplinary proceedings involving lawyers from Maharashtra. So the 13th August 1975 is the first time when we have an expanded notion of standing in the Dabolkar case. So after deciding that important question law, it was a 7-judge bench. They sent it back for proper decisions. And a second round of Dabolkar happened. And this was in 3rd October 1975, where the Supreme Court of India. Let me just see it out. Again, it reflects on what could be the role of the lawyer in the new system. And this is again Justice Krishna writing. I'm going to quote from para 24 of the second Dabolkar case, which goes by the citation of Bar Council of Maharashtra versus Dabolkar, 1976 2 SCC 291. This is the judgment dated 3rd October 1975. And this is what Justice Krishna says. We wish to put it beyond cavil, the new call to the lawyer in the economic order. In the days ahead, legal aid to the poor and the weak, public interest litigation, and other rule of law responsibilities will demand a whole new range of responses from the bar or organized social groups with lawyer members. Indeed, the hope of democracy is the dynamism of the new frontiersmen of the law in this developing area, and what we have observed against solicitation and alleged profit-making vices are distant from such free service to the community in the jural sector as part of the profession's tryst with the people of India. So this is envisaging a new role for the lawyer, expecting the lawyer to be involved in public interest litigation. And this goes back to 1975. I don't think the bar picked it up through all these years. Many of the people whom I talked to are unaware that there was a Gujarat committee report, or there's a 1957 Kerala rules, or there was a 1973 report. I remember when, as a judge at the Delhi High Court, there was an occasion to be involved in the work of the Legal Services Authority. We got published the 1973 report and the subsequent report, which was a 1977 report. I'm going to talk about it now. We got it reprinted because what we realized that it was not easily available in the public domain, and people needed to be aware of what was the whole purpose of this entire legal services movement, how it was meant to proactively take the courts to the people. So these two judges, again, the two judges I'm speaking about, Justices Krishna and Bhagwati, were fortuitously placed together in a 2-member committee set up by the government of India during emergency. And they gave this report on juridicare. It's called the Equal Justice. And that report frontally placed public interest litigation as one of the important tools to achieve social justice. So we have the 1973 report followed by the 1977 report. 1977 report authored by these two persons naturally drew on the earlier reports. So there's extensive reference in that report to the Gujarat Committee report and the 1973 report authored by Justice Krishna Iyer. What the 1977 report did, and it's so significant to note this, 2 sitting judges of the Supreme Court constituted this committee. These 2 sitting judges would not do the work of the committee during the court working hours or court working days. During weekends, these 2 judges would travel to various corners of the country. It's a remarkable process, and it's a compulsory reading to all the lawyers listening to this lecture. There's no excuse but to read these reports, to know what kind of judges we had, what was their commitment, what was their passion, what was their outlook, philosophy. And it was a great contribution to Indian jurisprudence, and we need to frontally acknowledge this. So there were 2 things happening. These judges sitting in the court act as judges, espousing all these causes of justice to the poor, and actually making important observations in cases that came before them. All of you will remember Motiram versus State of MP, which is the oft-cited judgment on bail. This happened in 1978. While the 1977 report had been submitted. Importantly, and this should be frankly acknowledged, was the change in the political scenario. If you will recall that emergency was declared in June 1975, it ended in March 1977. Through this entire period, the judgments that we have the Bolkar judgment, we have a judgment of Justice Sarkaria in not in a matter arising out of PIL, where Justice Sarkaria talks of the expanded notions of standing. So what was happening in the American courts, particularly following Gideon, was somewhere, in the minds of the judges, even in India, particularly the Supreme Court. And some of the judges already started talking about this. Sunil Batra is an important case that we should note because it predates Husainara Khatun. A petition was sent by Sunil Batra complaining about his solitary confinement. His death sentence had been confirmed, but he was kept in a solitary cell. And the inhuman conditions in which he was kept formed the subject matter of this petition. He first went to the Delhi High Court, didn't succeed. He filed a separate petition to the Supreme Court. Another petition that came to the Supreme Court was from this well-known prisoner, Charles Sobraj, who has been kept in human fetters. Of course, Sobraj's history tells us that he is probably one prisoner who managed to escape from many, many high security prisons, maybe because of that history. But he was permanently kept in iron clamps and fetters. And both these petitions were before the Supreme Court. Now, what is remarkable, and this is noted in the judgment in Sunil Batra, Justice Krishna had persuaded Justice Beg and Justice Singhal to accompany him to visit Tihar jail. And in one paragraph, he notes how they noticed Charles Sobraj standing with manacles both around his arms and his feet and his hands. And it made a powerful impression, this visit to Tihar jail way back in 1978 by 3 judges of the Supreme Court. I don't think even today you have sitting judges of the Supreme Court visit jails. But it changed the whole outlook. If you read the judgment in Sunil Batra, it's a very powerful statement on how court should be responding to cries for justice. And they treat those petitions, the appointed amicus curiae, Dr. Chitle, who's assisted by, who was later to become Justice Mukul Mudgal. Mukul was a young lawyer assisting Dr. Chitle and prepared excellent notes for the court to draw on. A lot of jurisprudence, you'll find American jurisprudence being drawn on, jurisprudence from the UK and elsewhere. It's a wonderful read, the Sunil Batra judgment. So they were dealing with the validity of Section 30 of the Prisons Act and a prison rule which permitted, I think it was Rule 54, which permitted manacling of prisoners. They ordered that he should not be continued to be kept in solitary confinement. They ordered manacles to be removed from Sobraj for a more humane treatment. But in that process, this whole epistolary jurisdiction, prisoners petitioning the courts, was frontally recognized. So this is an important case that we should not overlook. Sunil Batra is important for not only recognizing this epistolary jurisdiction and direct approach to the Supreme Court, but the recognition that the courts must reach out to the people. The reverse process had to start. And this was soon after the emergency, where the coalition government was in place. There was general political instability. And there was an awareness that the court had to respond to the needs of the people. In my earlier understanding, and which is part of my book, I understood whole of PIL to be an atonement by the court for the condoning the excesses during the emergency. Justice Bhagwati was very much part of the bench in ADM Jabalpur. He sided with the majority, and it was only Justice Khanna who dissented. Both Justice Chandrachud, Justice Bhagwati were part of that majority. And, given the background of Justice Bhagwati and his espousing the cause of the poor in the Gujarat Committee report, and in all these other committees, the 77 committee, it must have been something else that happened that persuaded him to side with the majority in ADM Jabalpur. Krishna Iyer was not part of these benches, but definitely knew what was happening during the emergency and in the court. So there could have been an understanding that somewhere the court had not responded the way it should have responded during the emergency. And that's probably what triggered this entire PIL movement. But I think the real answer is much earlier in the work that they did outside of the courts in the committees. They were already aware that many poor people are unable to reach the court for want of means, and that the bar was not responding in the way it should. The difference, I think, between the legal aid movement in India and the legal aid movement abroad is it's a bar-driven movement there in the US that brought the need for legal services, whereas here it is a court-driven movement. Whether it's legal aid movement, which of course got impetus from the judges as well as from the government, but it was never bar driven. And this is an important distinction that we need to bear even when we discuss PIL. So much for the origins of PIL. The initial years, if you look at the Balwant Singh Chaufal judgment, Justice Dalvir Bhandari's judgment of 2010, he traces three phases of PIL. In the first phase, he says that the court was concerned with causes involving the poor, the prisoners in jail, under trials in jail. And in the second phase were environment causes. Third phase, public accountability and governance issues. But I'm unable to see, when I see the whole spectrum of cases, I'm unable to see them in neat compartments like this. Because in the 80s itself, you had the 4 MC Mehta cases rolled out. MC Mehta was a very active lawyer in the 80s. And he brought the Ganga pollution case, the Delhi environment case, vehicular pollution case. And then he also got the 4677. That is it started off as quarries in Surajkund and became a complete huge PIL otherwise. So the early environment cases were brought by MC Mehta even in the 80s. Then you had the Bhopal gas disaster in 1984 and the Shriram oleum gas leak happening just 2 kilometers from the Supreme Court, and where Raju Ramachandran, the senior advocate, who's then assisting the court. So, and Justice Bhagwati sitting in the Supreme Court, it's postulating this whole, strict liability principle. So PIL became the vehicle not just for causes involving, the underprivileged and people without access to justice, but also went into environment issues and also went into issues unrelated to these things. A classic example being S.P. Gupta. If you will recall, S.P. Gupta, who was the father of our Sunil Gupta, senior lawyer, S.P. Gupta, the lawyer from Allahabad, senior lawyer from Allahabad, challenged the transfer of judges made by Mrs. Gandhi's government. And soon after she came back, and even some transfers during the emergency. And that became the subject matter of the first judge's case, which is S.P. Gupta, which is a public interest litigation case. So there, if you look at Justice Bhagwati's opinion, he holds forth on the entire philosophy behind public interest litigation, how it was really meant as a tool of legal aid and to achieve social justice. So the initial thrust was involving cases of the underprivileged and disadvantaged, people who could not reach the courts, and therefore the court had to reach out to them. And then you had expanding the notion of standing, where you had journalists, you had lawyers, you had medical practitioners, you had many public spirited citizens bringing cases to the court, and court also taking suo motu. So this court itself taking note was a fairly more a later phenomenon. Initially, you had many of the public spirited persons coming to the court. Another noted persons, the set of persons who went to the court were Professor Lotika Sarkar and Professor Upendra Bakshi, the Agra Protective Home case. And there were many such cases involving, persons behind in prisons, in Nari Niketans, in children's homes who needed to be, looked at. So how the high walls of these prisons were broken down, literally, and access provided through the system of PIL. PIL had its own set of facets, I must say. So one facet is, of course, expanded notion of standing. You have enough judgments explaining that. Second is the informality of procedure. So the relaxed procedure meant that you could send a telegram to the court, you could send a letter to the court, it could be a newspaper article which is converted into a petition. So and no insistence that it should be in a certain format with some prayer clause, with an application. All this was dispensed with if the court took it in its PIL jurisdiction. So relaxed procedure was one facet. Third, fact finding. Very often, just one paragraph letter or a postcard could be sent. To find facts, the court would send commissioners, fact-finding commissioners, who then find facts and come back to the court with a report. And even on aspects of, like let's say environmental pollution, some experts would be appointed to give a report to the court. So this was another facet of PIL where the court could find both facts and scientific facts, which the court may not be familiar with, but be assisted in its deciding of the case by these devices. Fourth was, of course, appointing amicus curiae. We saw how in Sunil Batra, Dr. Chitle was appointed amicus curiae. Likewise, in many of these cases, you had amicus curiae being appointed, that is, friends of the court, where lawyers are asked to assist the court. And the lawyers then become the main presenters of the case. So you will find there was a gradual displacement of the original petitioners or petitioners' lawyers. They would also be in court, but the court will essentially be dealing with the amicus curiae. All of you are familiar what happened in the forest cases, what is happening in the forest cases and other cases, where actually the court is engaging essentially with the amicus curiae. Another facet was what is called the notion of continuing mandamus. So in PIL cases, typically, you will not have one judgment at one point in time. You will have a series of interlocutory orders. Husainara Khatun is the best such example. If you look at that 1981 ACC, you will find a series of Husainara Khatun 1 to 8, all being published one after the other in that SEC volume. So that became a characteristic feature of PIL cases, where the court would keep the case before it for monitoring the implementation of its directions. And that was a very useful way of dealing with the matter, because very often when the case disappears from the board, the parties who are entrusted with specific tasks fall back. And it's very hard to bring them back to the table again. So the court very early on recognized that it will have to be controlling the proceedings and will have to keep monitoring the implementation of its own orders. So these were all the facets which fascinated legal academics, who took, who thought this as a great transformation of our judicial system, where people who earlier could not even think of approaching the courts were now able to be seen and heard by the court, if they could not come themselves, then through other public spirited persons. And therefore, a whole range of issues started getting dealt with in PIL. And there was a point when PIL became central to the functioning of the court. I'll shortly say about what happened subsequently. So these facets produced their own set of problems. Okay. So let's now look at the problems generated with this kind of functioning of the courts. And we're talking now not just of the Supreme Court, but the high courts as well. If you look at this article in this book called Supreme But Not Infallible, the late Attorney General Ashok Desai and I have written a piece in this book called Supreme But Not Infallible on public interest litigation. Mr. Ashok Desai recalled from his lawyer days in Bombay High Court how in 1974 he had actually filed a case on behalf of Mr. Pilu Modi against the government of that day, government of Maharashtra. And this goes by the cause title of Pilu Modi versus Maharashtra, where they were questioning the grant of leases of valuable land at an undervalue to three ministers. Through three ministers, like a discretionary quota. And there was a Justice Gandhi of the Bombay High Court who recognized Pilu Modi's, was a journalist, he recognized Pilu Modi's standing. So Mr. Ashok Desai said it became an unreported judgment. But it again is around the same time, I think, as the Dabolkar case. So in a Bombay High Court, this notion of expanded standing was recognized in the judgment, unfortunately unreported, but noted by Mr. Sirvai in his commentary on constitutional law. So in that book, we talk about the issues that PIL raised, and one major issue, and which continues even today, is the conflicting public interests. Just to take a typical example, a residents' welfare association brings forth a public interest litigation, saying there is huge encroachment of slums in the land abutting the building, which is, of course, lowering the valuation of the property, and therefore that encroachment must be removed. Even today, as I speak to you, there are many high courts which are approached by such petitions, and many high courts entertaining such petitions, many high courts ordering the removal of encroachments without hearing the slum dwellers, without making the slum dwellers a party. So here you have two conflicting interests. The interests of slum dwellers, a whole bundle of rights: the right to shelter, the right to livelihood, because many of them are persons working in the very apartments next to which the slums are. Many of them are city service personnel. When I say city service personnel, they're persons who work in the households, in factories, in establishments, in courts. So people who live in the Trans-Yamuna area, and I've lived there for more than 2 decades, early in the morning, let's say from 5:30, you will find many cycles cross the Yamuna Bridge. These are people coming to work from many slums in the Trans-Yamuna area, coming to work in the city. They could be sweepers, they could be sewer cleaners, they could be people providing basic services, health services, health-related services. So these go by the name of city service personnel. They have an entitlement under the master plan for Delhi to subsidized housing, which has never been fulfilled. Those targets have never been fulfilled. But the point I'm trying to make is you have one set of residents of apartments who are aggrieved by the encroachment by others. So these are two conflicting interests. Now, if a court entertaining the petition fails to recognize the conflict of interests, then it will be doing grave injustice to one set of the people who will never be heard. This happened even when closure of polluting industries in Delhi. You will remember those orders made by the Green Bench in the Supreme Court mandating immediate closure of several industries in Delhi. The point in law was well made, namely, there were non-conforming zones and conforming zones. In residential zones, you couldn't have factories because they were polluting. So they were non-conforming. And despite deadlines, they were never removed. So at one point in time, the court got impatient and said, I'm closing down. I'm ordering the closure of all these industries. What it meant was overnight, several workers lost their livelihood. And not livelihood alone. There's a whole bundle of rights that gets erased. One is the families that live around those factories. The right to shelter is gone. Children who are studying in the schools nearby, right to education is gone. Right to health is gone because you have primary health centers in and around the area. There's no access to health care. So you're suddenly from a so-called zone of illegality, you're thrown into a worse position, and there's no hearing. When we take petitions on behalf of such people, the first question that would be asked is, what is your right? Right? So it has taken many, many years of persuasion and argument for a whole jurisprudence to develop around this, around right to health, right to education, right to shelter. But in one order of removal of slums, several rights get obliterated. So we've now had through PIL the evolution of the jurisprudence around rehabilitation, resettlement. So which is why under the new land acquisition law since 2013, you have an entire schedule for prescribing standards for resettlement of displaced populations. But this has happened throughout the country and for all these decades, which is why we've never been able to meaningfully handle the problem of slums in this country. So this is one instance of conflicting public interest. Again, environmental causes was the people. If you look at the Sanjay Gandhi National Park in Bombay, the environmental groups got the court to order removal of encroachments from the Sanjay Gandhi National Park in Borivali, saying that the parks pristine beauty has to be, not only beauty, the green cover has to be preserved. So very often you will have two conflicting. Then it means overnight removal of people around even the fringes. Even in all these national parks and reserves that have been declared, you will always have someone getting displaced. The question, if it's a very simplistic question, what legal right did these people have in the first place? The answer could be no. But it's not just about the right to remain in that place. The whole set of rights that you have as a human being, which the Constitution recognizes, which many judgments recognize. So how do you then account for all these conflicting interests is something that PIL has to deal with. It's a complicated issue. If you try and simplify it, you cause grave injustice. So one outcome of this was non-recognition of conflicting public interests. Like I open the morning newspaper. Many lawyers do that, even today. I feel very strongly about something, right? I say, okay, let me go and file a PI. Many lawyers don't do that basic homework of trying to find out the full facts, of trying to understand the full context in which a certain incident has occurred. You have a knee-jerk reaction. Many judges have knee-jerk reaction. Suo motu. I read, as a judge, I read something in the newspaper. I go into the court, I say, suo motu, let's register this case. There could be many more complications from what is projected in the media, right? Which we are not aware of. So these things can have its own set of problems. And we are seeing that those problems play out. So what happened is, over the years, we found that the focus in PIL had shifted from its original purposes, which is, reaching out to people who are in a dire need of justice, to the focus shifting to cases of environment, which is much needed. It is still engaging the court, to cases of public accountability, which is also needed, and governance, where, like, for instance, prosecution of people in power, and accountability for their actions, where police doesn't register a case, the government of the day is not interested in pursuing the case, you need the court to interfere. You had the whole 2G scam, the cases that associated with it earlier in Bihar, the fodder scam. All this came through PIL. The setting up of special courts, setting up of special investigating teams, because you can't trust the local police, you can't even sometimes trust the CBI. So you have to form a special investigating team. But all this also meant that it was a lot of power in the hands of the court. So many judges are fired up by this judicial power that they suddenly find in the writ jurisdiction, particularly if they can take up suo motu cases and give a whole string of directions and orders. Now it has its own flip side. If individual judges in the high courts start exercising such suo motu power, it becomes unmanageable. So we've had, as a pushback on this, a whole set of PIL rules being formulated. So these rules in PIL originated in the Supreme Court. If you now go into the Supreme Court registry, you will find a PIL section. You will find a PIL English and PIL other. Basically, a lot of letters come into the Supreme Court in various languages. If it is in English, of course, it's dealt with the PIL English section. So there is a cell there which screens out. So there are a set of rules about what matters will not be entertained as PIL and what can be entertained as PIL. Then it is placed before the court. But in many high courts, they have a further screening. Apart from the PIL cell itself screening, you have a committee of judges which examines this and finds that if the matter is fit enough to be placed before the court, it will be placed before the court. A further rule that has been devised is that it will only be placed before the bench of the Chief Justice. And if the Chief Justice then places it before some other bench, it can be done. But it has to go through the bench of the Chief Justice, because you have instances where a judge feels not necessary to place anything before the Chief Justice and starts passing orders on the judicial side. It's an embarrassment. So these rules have been formulated to ensure that PILs are not filed on landlord-tenant matters, service matters, personal matters of private interests, but only in genuine public interest matters. Of course, there being an exception clause saying if the court takes up a suo motu action, these rules will not apply. So now there is a whole standard set of rules in the state of Uttaranchal versus that Balwant Singh Chofla, which is a 2010 judgment. Justice Dalvi Bhandari insisted now that the High Court should all formulate rules. So when we had informality of procedure where even a letter could be sent to the court, we've now moved to a position when there are rigid rules governing PIL. In fact, you have the Delhi High Court rules literally being copy pasted into the Karnataka High Court rules with some more things being added. What is interesting in these rules, you'll find what para 1 should say, what para 2 should say, what para 3 should say, how you should demonstrate your genuine public interest, how you have to disclose your identity. You have to even disclose your sources. Who is funding this PIL? Good enough, but will you be in a position to pay costs if the court imposed costs? So it's become a very, very elaborate petition now with certain mandatory paragraphs. So from a relaxed procedure, we have now a very rigid procedure. In fact, I think this kind of a procedure is not prescribed even for regular writ petitions as they are prescribed for PIL. So this is a whole arc where we started off with epistolary jurisdiction and no rules of no rigid rules to extremely rigid rules of procedure, which govern not only the Supreme Court. You have a chapter in the Supreme Court rules on PIL. And in many high courts now, there are rules governing PIL. The other problem that has been flagged in our article is the problem of displacing of the petitioner. This started with Sheila Barse case of 1988. She had sent a petition to the Supreme Court about the languishing, large numbers of women and children in jails. Children ought not to be in jail at all. They were with their mothers. And she wanted to find a solution because the children were not accused of any crime. They were just there because the mothers happened to be in jail. Now, this petition kept pending for more than 5 years or 6 years after she had sent this petition. And typically, the states were asking for time for counter affidavit, even in 1988. So at one point, she got exasperated and she told the court, listen, if the court is unable to proceed with the matter because they don't file a reply, let me withdraw my petition. At which the court said, no question. You brought a cause before us. If you are not able to pursue it, we'll appoint the Supreme Court Legal Services Committee to take it over. So the displacing of the petitioner started there. Now, the difficulty is how much a petitioner who's passionately involved in a cause can pursue, can collect facts, can place before the court. The committee cannot be expected to do in the same vein unless it appoints lawyers who will do this task which a petitioner might have done. Amit mentioned the sanitation workers case, Safai Karamchari Andolan. I remember how many states were in denial that dry latrines were being cleaned by persons, sewers were being cleaned by persons. Very often we had to counter it by placing photographs and video clips before the court. Now imagine if that case, the Safai Karamchari Andolan is replaced by the NALSA or Supreme Court Legal Services Committee or some legal services authority. They will not be able to do the kind of work that a Safai Karamchari Andolan's members will do across the country. They will go to the nearest place, do a fact-finding, cross-checking, and be able to send a report back, which can then be placed before the Supreme Court. So this displacing of the petitioner, either by a body or by an amicus curiae, has its own set of problems. Many of you have filed applications in, let's say, the forest matters, Godavarman Tirumulpa. There is an amicus curiae. Earlier, it was Harish Sarve for many, many years. Then Justice Lalit, who was a senior lawyer for many years. And now you have many other lawyers, senior lawyers, being appointed as amicus curiae. You have a whole bunch of applications. And you want your application to be taken up. Let's say one application is from West Bengal, one is from Kerala, the third is from Gujarat. Now, the amicus curiae has to decide in which order will these applications be taken up, which applications will be taken up. Because the listing of a forest matter may happen once in 3 months, once in 4 months, sometimes once in 6 months. So he has to decide the priority. And your application, which you think is a great priority, might not even be taken up at that hearing. So this has caused a lot of discontentment on the way the amicus curiae controls entire proceedings. So this is a matter for concern, the displacing of the petitioner. And then, do I have time, or is it going on too much, Aditya? Do we have time, or should I stop?
Sir, certainly we can go ahead, sir.
Okay, okay. The other issue, related issue, is the need for transparency. In many of these PILs, reports are called for, expert reports. Those reports are not immediately shared with the PIL petitioners themselves. Since the petitioners have got displaced and it's an amicus curiae now in the picture, it's essentially a dialogue between the amicus curiae and the court. So the petitioners who originally brought the petition, or all the applicants who have been affected by the orders of the court, don't get a chance to see that report or comment on it. Now, in a regular litigation, let's say one party produces an expert report. The other party may want to contest that and then produce its own expert report. And then you have this principle of what is called hot tubbing. In arbitrations, it happens. Two expert reports are analyzed by the arbitral tribunal, sometimes by the court. But that kind of an opportunity is not available in PIL. And therefore, there is a concern about lack of transparency in PIL proceedings, where many things happen between an amicus curiae and the court, and maybe the governments, but without the involvement of the PIL petitioners or persons who may have something to say on these issues. Let's say the forest matters. Some wildlife experts may have a different point of view, but they will have no platform to make that point. They will be told, whatever you have to say, please tell to the amicus curiae. Now, the amicus curiae is saddled with a whole lot of issues and petitions and applications. So this does create a whole set of issues. The other major concern that generally has been voiced is that of consistency and continuity. Some judges are very passionate about some causes and they move on. After retirement, you will find that petition is not picked up at all. It gets, in a sense, orphaned. It disappears from the board. You remember when Justice Lokur was there was what is called a social justice bench. When Justice Kuldeep Singh, there was a green bench. So you will have some moments in the court's history where some judges are very enthusiastic. So they will then place those matters in regularity, with fair regularity on given dates, and keep engaging with the issue. The other judges may not share the same passion, may not have the same focus or interest. Focus shifts. So what was very important at one point in time today is not even talked about in the court or in the in the bar. So this is something that we are having to contend with. Then high courts dealing with parallel petitions as the Supreme Court. So in Orissa, to overcome this, I've made an attempt as a Chief Justice to set up what is called a PIL portal. So today, if you go to the website of the Orissa High Court, you will find this PIL portal. In that PIL portal, I've listed out all the pending PILs in the Orissa High Court. Not only that, I've listed out, I've placed on, along with those details of the petition, the orders passed right from day one till the last order in each of those petitions. Sometimes I've given you a link for the live streaming of the hearings of those petitions. And another, I've given you the link to the reports submitted in those proceedings. Let's say olive ridley turtles. What were the expert committee reports in that issue? You will find it on the website there. I'm very, I'm hoping that this idea of placing details of pending PIL petitions is replicated not only in all the high courts, but most importantly in the Supreme Court. I think the bar should make a demand for it. And it's got many, many uses. One, the entire country knows what kinds of issues are now pending the Supreme Court, what are being entertained, and what are the orders passed. Because these are all actually public interest litigation cases. They involve public interest. So they should be in the public domain. Second, expert committee reports. Not all of them involve some great trade secrets or anything. And anyway, you can have a policy for redaction in case you find there's something sensitive which should not be disclosed in the public domain. You can, for valid reasons, redact it. But public should know what have the experts said on this issue, right? Let's say the latest judgment of M.K. Ranjit Singh on climate change, the great Indian bustard, that species of birds that needed protection. There are expert committee reports. So that should be made available in the public domain. Likewise, stances taken by the governments. Just on the Justice K. Puttaswamy case, in the privacy case, public interest litigation, conflicting stance taken by successive governments. Government A is now one political dispensation. That same government A has another political dispensation 2 years down the line. they file dramatically opposite affidavits on certain issues, on the stand taken. Public should know it. There should be what is called building up of an institutional memory. It's very important for future that we know how these public interest litigation cases have progressed. What was the approach, not just of the litigants or the state, but also of the court itself? How frequently they dealt with this issue? Today somebody files a new PIL. There are already some 3 PILs pending on this issue, but nobody knows it because those details are not available in the public domain. In Orissa, after we put up this PIL portal, many lawyers realized, okay, on this issue, there is already a PIL. No need to multiply litigation. So this is one major issue that has plagued the entire PIL jurisdiction on continuity, consistency, and certainty. To a certain extent, you need the PIL to be brought to its logical conclusion. Kadra Pahadia was a PIL that started in the 80s in the Supreme Court about people languishing in jails. It finally ended in 1992 or 1993. There are some PILs which have not ended at all. So we need to know why this happens. And if you look at the Godavarman or 4677, many of you will recognize this 4677 of 1985, this PIL involving Delhi, which started with the Suraj Kund, the quarry workers, and now it's gone on to many other issues, including unauthorized constructions, whatnot. If you look at the Supreme Court registry, if you walk into it and ask them for the 4677 files, it will probably fill up 10 cupboards. You will have thousands and thousands of IAs. Nobody knows where it started, where it now is. So there's no continuity. There is no consistency. Third or fourth issue is, at one point in time, there's a fatigue that sets in many cases. The court says, now how many years am I going to deal with it? Right? So at one point in time, it happened. It happened in the Safai Karamchari Andolan case. It happened in many other PILs. It happened in the PUCL case involving, bonded labor. The court said, okay, now we are either sending it to NHRC, we are sending it back to the high courts. So you have green benches in the high courts. So, and now all high courts don't deal with the same issue with the same regularity, the same seriousness. Again, it depends on the lawyers espousing those causes or groups in those states espousing those causes. So this again has caused great, concern among the litigants. But this much is certain, the PIL jurisdiction forms the central part of functioning of our high courts and Supreme Court, because many causes which otherwise would not have seen the light of the day get visibility through PIL. But from the lawyer's point of view, and I want to end my lecture with this, because of my long experience in this arena of PIL, human rights, both as a lawyer and as a judge, I would just want to suggest what lawyers should avoid doing while dealing with PIL cases. And this is just a rough list. One is, lawyer himself or herself becoming a petitioner in a PIL case is not a good idea. We bring in with us several prejudices. We claim to know several things which we actually don't. And somewhere we lose control of a case if we are inadequately prepared. Even an MC Mehta, and I must say this, MC Mehta was a lawyer, even an MC Mehta who did so much for environmental causes at one point was displaced by amicus curiae, because there's only so much the lawyer can do. It's better to leave cases involving scientific facts and scientific, data to experts. So always associate people directly involved in the cause. They may be public-spirited persons, but it's important to involve such persons who will give you the right, kind of direction and advise, suggest to the court appropriate orders that are to be passed. That is one. Then vetting of PIL petitioners. PIL is getting misused. Of course, there are many instances of misuse of PIL. Not only there's been criticism from amongst lawyers, but importantly by judges themselves. So you will have all these appellations, publicity interest litigation, political interest litigation, paisa interest litigation, all kinds of things judges have said. They've been very, very critical of what other colleagues have done in entertaining certain PILs and passing certain orders. But this misuse of PIL can be to a certain extent curtailed if lawyers do a basic homework of checking the background of the person who's approaching you. Is there actually somebody being set up to achieve a collateral end? So if the lawyers don't do that basic work, then they will contribute to the misuse of PIL rather than mitigate its misuse. And then this having to be thoroughly professional. What I used to find is there are what are called lazy PILs. See a newspaper article, write some 3 paragraphs, attach that as Annexure 1, file a PIL. Sometimes the judges do entertain it, but 9 out of 10 times the judges will be very upset, saying you've done no research, you've just had a knee-jerk reaction, you're wasting the time of the court. I always talk about what is called the Brandeis brief. And I know Amit will bear this out. I attempted it in several of my PILs, which I filed, and not all of them succeeded, but it was a learning exercise. When you gather data, when you gather the scientific facts, when you talk to experts, you have to reach out beyond your discipline of law. You may have to talk to economists, sociologists, scientists. You have to understand it from their perspective. When I was doing cases of eviction of slum dwellers, defending the slum dwellers, I used to talk to urban planners. They have a different understanding of the master plan for Delhi. I learned a lot from them. So this engaging with other disciplines is something that a PIL lawyer has to learn to do. And that basic homework, if you don't build up what is called a solid brief, then your petition is likely not to be taken seriously at all. The better you research the petition, the better the results might be in court. And also exhausting those other remedies. When you start the PIL case, instead of rushing straight to the court, try and engaging with the agencies. If there's a pollution control board, if there's some other body that has to be first approached, do that. Exhaust that. Don't have the court tell you first go back. You will treat this petition as a representation. It doesn't help your constituency. Next, don't stand in between the court and that person whose cause you're espousing. Many of these groups who come to you have to be still involved in the matter. What happens is a tendency for the lawyer to not go back to the clients at all and keep engaging in the matter, doing what the lawyer thinks best. And this is a very dangerous thing. And there is a politics also. They have their politics. Many of these petitioners have their politics. As a lawyer, you must be able to ensure that politics is not compromised. Their agency, their control of the matter is not displaced. So very often we don't go back to the constituency. I used to go back to the actual slum dwelling, sit with the slum dwellers, explain to them what is happening at every hearing. What is the court asking? What is the other side saying? What should be the strategy? You have to involve people for whom you're espousing the cause. And somewhere, midway through the case, that disconnect occurs, and then those constituencies distrust the lawyer, saying it's now become a case between the lawyer and the court, and we are nowhere involved. And that should not happen. Don't multiply litigation. I've already spoken about it. Don't hold press conferences yourself. There's a tendency, because it's also publicity for the lawyer. It's a very natural human tendency. But if you start talking about the case yourself, something goes away. And, this personal interest that the lawyer has in the litigation takes away from the seriousness. This is my own personal experience. So I would refuse to even give that 2-minute bite, which the press reporters desperately asking. They are in court, they are observing the proceedings, they will write about it. You can share pleadings, there's no difficulty about it. But sharing pleadings in advance is a problem. Today, I have filed a PIL petition to the Supreme Court. It has, let's say, 10 defects, 20 defects. It's not even numbered. It's not even listed. It has already gone to the press. This tendency must stop. It not only irritates the court, it actually sometimes defeats the cause, because you sometimes need to be preserving, that interest till it's actually taken up by the court. So avoid holding press conferences yourself, speaking to the press yourself. By all means, share information. There's no difficulty. But this personal involvement of, giving interviews is actually counterproductive. Then staying with the cause. You must learn to persevere. There may be some benches which are receptive, some benches which are not, some benches which are openly hostile. Don't become emotional. Stay professional. Have a sense of detachment. Don't lose your patience. Engage with the court. I'm taking the example of the Safai Karamchari Andolan case itself, or Bhopal gas victims cases. There were many a time when the bench would change. You have to start all over again, but you have to do it. You have to maintain your calm, because you see, you're standing for a whole constituency. It is their day in court. You cannot jeopardize that. And you still have to persuade the judges to hear the case. So there may be many a frustrating day in court, but don't give up on that cause, because The people who are waiting for justice haven't given up. And you are there with all your experience and understanding of the whole system to make sure that their day in court is not, jeopardized. Bad PIL days teach you more than the good ones. There are many PIL cases which were so well researched and so well prepared, got thrown out in 2 minutes. These things do happen. And learn from that. Actually, and that's where I'm saying sharing. I talked about the PIL portal where the court puts up information. PIL petitioners should not keep information from each other. This is a tendency which again destroys the cause. And then you start arguing at cross purposes. You hold back information which doesn't help anyone at all. So these are some of the do's and don'ts which I thought I should share. And I'll end up with 2 funny episodes that happened. So just sitting with Chief Justice A.P. Shah in the Delhi High Court, it was the Chief Justice's bench. So every afternoon, we'll have mentioning at 2 o'clock, there would be a Mr. Pandey who comes. Okay, he was a person who was a lot of concern. He had a lot of cases. He would bring with 2 heavy bags of papers. And he will start off. The minute we sit, Mr. Pandey will start off. And Justice Shah would say nothing. I mean, he would keep nodding his head. And after the 3rd or 4th day, I turned to Justice Shah. I said, why are we doing this day after day? He said, listen, this man is suffering from litigation neurosis. He's had, frustrating years in the court. He needs to just come in and vent his, a frustration or anger or emotions. Let him do it. And, this was something that I learned from Justice Shah, that there are many such a litigant who are deeply frustrated, because one day Mr. Pandey came and said, sir, in 2 hours from now in Switzerland, the Hadron Collider is going to start, and that must be stopped. It was so absurd, but then he had to be allowed to say whatever he had to say and move away. The other is an anecdote told to me by Justice Madan Lokur, who was sitting in the Delhi High Court at that point in time with Justice Jagannath Rao, Chief Justice Jagannath Rao. And there was this PIL petition, the petitioner in person, who was saying that this statute is unconstitutional. They said, why? He said, it's violative of natural justice. They said, why? They said, he said, they didn't hear me before making the statute. And therefore, I've made the parliament a party. I made the speaker a party, and so on. So they tried telling him, listen, this is absurd, but he wouldn't listen. So at one point in time, they said, if you go on like this, you will even say that President of India should not have signed the bill. He said, precisely, my lord. He is respondent number 5. So, so there are many such personal representatives in PIL cases who need guidance. And invariably, the court will turn to some lawyer and say, can you help him out? And as a lawyer, you'll have to be patient with such a person, explain the whole system to that person and say what can be done, cannot be done. Of course, beyond that, if the person doesn't listen, he doesn't listen. But this is something that as a lawyer, we have a responsibility to the institution and to the cause. CPIL has its own wonderful, uses. Like I said, visibility, also developing what are called principles of public law. You have had the polluter pays principle, the precautionary principle. Talk of many things. The whole right to privacy came through PIL. Many facets of the right to education came through PIL. So you had Vishaka, the rights of women against sexual harassment in the workplace. Many of this became legislation later. So the impetus came through PIL in court. Even the Nalsa litigation, now you have a legislation for trans persons, but the impetus came from the court. So we have a vested interest in one sense in making sure that this jurisdiction is strengthened and not weakened, and it's given the right shape and direction. I hope this lecture has been useful. I'm waiting for the questions and reserving some of my better comments for the questions. Thank you so much.
It was indeed a very thought-provoking session, Dr. Muralidhar. And before we jump on to the question answer round and vote of thanks, I want to extend my heartfelt gratitude for sharing your vast knowledge and expertise with us, sir. And from the inception of PIL to its evolution, we have gained invaluable insights into the purpose and power of PIL, sir. You have beautifully covered the misuse and abuse, lack of locus standi, judicial activism, delay in pendency, inadequate representation. And now, with a deeper understanding of its significance, I believe we are now better equipped to harness the potential of public interest litigation, Dr. Muralidhar. And let's now move on to the question answer session. We have received several thoughtful, questions in the chat box. 90%, sir, you have already covered. So whatever limited I can, put across. So we have first question that costing in PIL is a challenge for the person opting to file the PIL on a serious breach. So how come a person can overcome this hurdle?
Which hurdle? Sorry, can you repeat that? Costing.
Costing in public interest litigation is a challenge for the
No, what is
person
it?
who's
Costing? Can you just
costing, sir, the monetary aspect of
monetary?
yes, yes.
Yeah.
So
Yeah. See, one is this is a definite problem. In fact, Amit is here. Very often the PI lawyer ends up paying everything. Costs of the petition, costs of everything. So if you're not able to do it yourself, take it to the Legal Services Committee.
right.
Section 4 of the Legal Services Authority Act. One of the functions of that Legal Services Authority is to espouse social action litigation. It's there in the statute. NALSA filed a PI, correct?
Right.
Supreme Court Legal Services Committee has filed PILs. When I was a member of the committee, I persuaded them to file PILs on certain serious issues. So if you cannot do it yourself because of monetary constraints, do approach the nearest legal services authority. It could be taluk, district, state. See, sometimes we don't test it out. We have to make that effort. Sometimes the secretary sitting there will say, no, this committee is for legal aid, it's not for PIL. We will have to point out that section 4. So I'm just saying there are many ways of approaching it. And also referral. There are many organizations working on these issues, whichever that issue is.
Yes.
So you must be able to tie up with some of those organizations, genuine ones, of course, and ask them whether they'll be able to support financially the litigation. So that reaching out.
Well, that answers the question.
Yeah,
sir.
Amit wants to say something.
I can tell you that I have witnessed all the PILs that we've done. In fact, my inception in the office started from towards preparation of a PIL that was with regard to manual scavenging. And I can tell you that I can vouch for, sir, not a penny was charged from any of the litigant in a PIL. Even for a photocopy, it used to be by sir. So, and I'm sure everybody, all of us have expenses. So I am sure that sir used to save that, cut his expenses, save that money for this PIL. So that's one way of doing it. This is according to me.
Thank you, Amit, sir. So next question is from our colleague. She says, recently PIL has been used for political parties to settle scores. Judges do not question credibility of PIL petitioners. Now it has been used to get CBI and ED in cases. And one connected question is that it has been.
What's the question there? What's the question there? It's only a comment.
Yes, sir. I'm continuing with that. It has been observed over the period of time that PILs can lead to conflicting court decisions, creating uncertainty and confusion. So how can we deal with that?
No, so on the first question, if you go back in history, there have always been political parties. You see, the court is a democratic space, right? Anybody can come into that, walk into the democratic space.
Yes, sir.
You will have petitioners like Sushil Kumar Modi, the politician from Bihar,
Right.
highly regarded politician who recently passed away. He was in the forefront in the fodder scam. People from Bihar will know, and this fodder scam thing began in the early 90s, right?
Yes.
So you have judgments that say merely because he's a political person does not mean that we will not entertain the PIL. So there is on one side that, right?
Yes.
Dr. Subramanian Swamy brought so many PILs.
Of course, yes.
Some entertained, some not. I'm just saying, now you have the BJP party person, I think Ashwini Kumar Upadhyay. Correct?
Yes. Yes.
Yeah, he doesn't hide the fact that he is a BJP,
Yes.
politician, but he brings forth so many PILs. So that's why I'm saying the court will look beyond the cause and see if the cause really has to be entertained, notwithstanding that the politician has brought, but the not disclosing that you're a political person or you're fighting on behalf of the political person causes those problems. But this is not new. And even the second part of the question, I'm saying it's a problem generally with the institution. It's not just with PIL.
Yes.
Just look at arbitration law. The quick overturning of judgments, referring to larger benches, whether the agreement should be stamped for the arbitration clauses to be acted upon. has gone
Right.
to, you see, I'm just saying, in many areas and branches of law, you have uncertainty, inconsistencies between benches. In judicial indiscipline, some single judge in a high court will say, I will not follow the division bench. I mean, you saw a direct demonstration of that a few days ago. But I'm just saying, this is, you as lawyers, you do it. You're
Yes.
faced with 1-2 judge bench judgment, the other, what do? You don't say refer it to 3 judge bench. You say, sir, this can be distinguished, peculiar to the facts of that case. So this is generally not just for PIL about uncertainties and conflicting opinions. Generally, that's a system. So that's a larger question. That's a larger question of how do we avoid, how do we reduce those possibilities of conflicting decisions?
Thank you, sir. Sir, how many more questions can we take, because our chat box is
I'm okay as long as your link is alive. So we can go for another 10-15 minutes.
we have a slot for 3 hours, sir.
Whatever. Yeah. You know, this is a funny episode. There's a person not known to be brief at all right? So he started introducing a major speaker, and the introduction went on for 1.5 hours. And the
Oh.
entire event was only for 2 hours. So the speaker got up, he said, I'm glad to see the printed text of my speech in all your hands, and I will take it as read. So after this embarrassing thing, that introducer was asked to preside over the next function some months later. This time he was wiser. He asked the organizers, he said, how long can I speak? That man said, sir, you can speak for however long you want, but we will listen to you for about half an hour. So that's the answer to your question.
With that, I only take 2 last questions, sir. So, there's a
That's a third episode in that. So when this speaker, who was the introducer there, was being introduced by another person, he said, this great speaker, he needs no introduction. He only needs a conclusion.
So, sir, 2 last questions from our side. Courts often overstep their boundaries, venturing into public making and executive function. So what are your thoughts on that, sir?
No, this is this is a systemic issue. All right. You'll always find this. We are still grappling with several things. Right? You will have some judge go completely off tangent. Right? PIL starts on one issue, it now becomes something else altogether.
Certainly.
So these are fancies. So the whole critique of PIL is, judges see this as a source of judicial power, not of accountability. As long as the judges view it as judicial, as a jurisdiction of accountability. And when you're enforcing accountability, what is PIL all about? Enforcing accountability to law, right? You're hauling up governments. You're saying you failed in your responsibilities. You're accountable to a system. We're going to enforce that accountability. So that accountability equally applies to the institution itself, dealing with PIL.
Right.
So that recognition has to be there. When that recognition is not there, all these problems will arise. Excesses, taking over functions, telling them what to do, what not to do, becoming the experts. See, the ability to deal with an issue is always there. See, competence and, what do you call it? Capability.
Capability, right.
Right? Competence, you don't even have the jurisdiction to deal with where you're dealing with it. That's point number one. Capability, you know this area at all. You can't suddenly become the expert. Interlinking of rivers. As a judge, I'll tell you, link up Bias and Sutlej. You can't do that. There's a whole, you see, these are fanciful ideas that judges might have. But it involves a lot of, other intricacies and complications. Right. So this is something that we have to, work at. The more we discuss it in the public domain, the more we write about it, there'll be a greater awareness.
Thank you, sir. And sir, the last query is that PIL can lead to conflicting court decisions, creating uncertainty and confusion.
I've answered that already. It's not unique to PIL. It's not unique to PIL. See, in our hierarchy of systems and multiplicity of courts, unlike, let's say, the US Supreme Court, of course, we don't want a US kind of Supreme Court, I suppose, where, the political inclinations of judges are clearly spelled out. But our problem is multiplicity of benches.
Yes.
See, polyvocality is, of course, something to be celebrated, that, we have a diversity of opinions. But it can lead to these kind of problems when, we have many 2-judge benches. And then there are 3 judge benches.
Yes.
And then 2, 3 judge benches will not follow each other. And then we think it's the Supreme Court which is speaking. Like yesterday, 2 judges talked about the hijab rule in a private educational institution in Bombay.
Correct.
Now, this will be said as a headline that Supreme Court says this. Now, as lawyers, we know these were 2 out of 34.
Correct.
Look at Sabarimala, right? 5 out of 34 said something. Within a few months, 7 out of 34 said something else.
Right.
And 2 of these 5 were part of that 7. Right? So
Right.
this is not peculiar to PIL. It's part of the system's functioning itself, which the more we discuss, the more we reflect, the more closer we will be to finding a solution.
Thank you, Dr. Muralidhar, for your patience and insightful responses. And now it's my pleasure to invite my colleague Selvin, member executive of SCAORA, to give a vote of thanks. Selvin, please join me in expressing our sincere appreciation.
No, Selvin, you're not bound by that direction. Speak your own mind.
Yes, sir, yes. So, good afternoon to all. And we have a special speaker today, Dr. Muralidhar. And so we are so thankful, the entire association, on behalf of all the lawyers. I'm giving the thanks, my lord. And I would like to say a few on lordships. Like every law student, they're very interesting about the moot competition. So it was when I asked the judge, when I was doing a clerkship, I asked him, do you have any idea about moot court? Because I have a competition, please guide me. He said, my friend who's in Delhi, he has a lot of ideas about moot. You can ask him. I said, who is that? He said, Justice Muralidhar. Then I said, wow. He said, he went in 1984 from Chennai to attend the 25th Philip Joseph Moot. So I think better you ask him, he would guide you. But it was in 2014, and later he was retired as a Chief Justice of a Kerala High Court. This is Manik Kumar. Yeah.
We played cricket together.
Yes. And more than a judge, this is Muralidhar being a great human being. Like in February 2020, like in the late night hearing of the Delhi High Court, which took place at Sir's residence. So it is regarding the Northeast Delhi riots. So there were many victims who were injured and their lives at stake. So by the virtue of the Lordship's order, the 19 people, 19 lives have been saved. And it is put an end to the carnage of that particular riot on the same day. So apart from all the, all the speech we had a human insight. The humanity always, my Lord, has come forward to help the fellow humans. That's one such quality which we are lacking in today's life. And it is very unfortunate that the Supreme Court has missed to have the golden opportunity to have you on the board. But yet, I would say that you are the boldest judge ever.
I think they've given me a golden opportunity. I'm back in the bar.
Absolutely.
Absolutely. Actually, we are thankful for the system.
For a man as a judge, we would have had a greater opportunity to represent before you and argue case in front of you, as every lawyer dreams to be in court to argue a case. And I would like to conclude this, that when he was Chief Justice of Odisha High Court in 2022, so there was a great initiative behind this visionary step that the paperless courts have been done. There were 30 districts of Odisha have 20 virtual courts established. So the eco-friendly mode, the visionary behind you, it requires for this entire legal system and for the judiciary. We are so thankful for today, for the golden time you have given us. We know that you are busy with all the conferences. Thank you so much, sir. Thank you.
Just
Yes.
before we close, Dr. Muralidhar, your transition from the old Maruti van parked at gate number D of Supreme Court, and again when you come back to Supreme Court, it's a whole life cycle.
Right.
We have seen your growth as an advocate, as a AOR, you're part of our community, and then as a judge, then as a Chief Justice, and you're back now in your second avatar. And what I feel, I share with all my XCD committee, in your quest for justice in the PIL system, you have legally weaponized the thoughts which were radically floating. You structured it and you've absolutely collated it for the whole body of lawyers to be enriched from. And now that you're back in Supreme Court as one of the jewels of the crown, we look forward. What a masterclass it was. And it's an education to everybody, right? From Gujarat, Kerala, US, you've covered it. And SCAORA, as you are all aware, we also have done our bit in the fight for judicial independence and such a critical judicial intervention by our association. We hope to carry this forward, and we will need your assistance in this also.
Definitely.
Great.
Thank you all. Thank you so much.
Thank you.
Thank you.
Thank you, sir. Thank you.
Thank you.